Greetings. We have constitutions, various countries in the world, and every country in the world have a constitution. Of all the constitutions, British constitution is supposed to be one of the best, if not the best. Now, the beauty of British constitution is that it is an uncodified, evolving framework based on statutes like Magna Carta Bill, etc., common law, parliamentary conventions, and works of authority. Now, what is the meaning of uncodified? There is no single document. The Constitution is scattered across various sources. Common law is established by judicial precedents and court decisions. So, come to think of it, what we are doing in Guide to IBC is that we are only taking court cases of NCLT, Supreme Court, High Court, and creating uh, topics out of that and presenting the insolvency bankruptcy code to you. So, which is actually not just uh, it is not it is showing the entire expanse of the law. It is not confined to the to the to the black and white what is written in the law books of act of the code, the regulations only. It shows the entire expanse of the law. So this is a very scientific way of learning insolvency bankruptcy code, and I suppose interesting also. I have come this podcast to you comes with the judgments of the last 2 weeks of January 2026. There are not too many Supreme Court judgments, but however, the judgments are wonderful. I think you'll enjoy the presentation, which is going to follow soon.
You can see Guide to IBC homepage on your website, on your screen. We normally do this podcast based on chronological order of sections, usually from low to high sections. This time it is going to be just the reverse. We'll take up higher sections first and then the lower sections. So our first case deals with bankruptcy and restrictions on bankruptcy. So let me take you to bankruptcy, individual and firms, and then bankruptcy order. We are straight away going to section 141. It says the adjudicating authority may allow the bankrupt to travel abroad subject to certain conditions. The case is Mr. Zankar Singh, Kishore Singh Solanki versus Kanhaiyalal Salawat and others. This is an enclave matter. Here the person is a personal guarantor who is now adjudged to be going through bankruptcy process. The bankrupt wanted to travel abroad to USA between 10/12/2025 to 31/1/2026. Now, there are matters pending at ED, High Court, etc., etc. But while they remain, he also needed permission because according to Insolvency Bankruptcy Code, there are restrictions on bankrupt. Bankrupt is not allowed to travel abroad. So the permission of NCLT is necessary. NCLT gave certain permissions, gave the permission to travel, subject to certain covenants, subject to certain restrictions. So let me take you to the screen share to make this more understandable. Now, I have already told you the topic, so I'm not repeating the same. The adjudicating authority exhaustively considered the pleadings of all parties, recorded subsequent developments and things, and then adjudicating authority here stated that placed a condition that the bankrupt should deposit 40 crore as security. Now, NCLAD was of the view that a person who's a bankrupt is not supposed to be having any source of earning. All his liquid assets and assets are in the custody of bankruptcy trustee. So how does he make a deposit? Security, provide a security of 40 crore. So this particular part of order of NCLT was set aside. However, however, there was another condition that two bond solvent securities of 50 crore each was to be given by funds. So NCLT was of the NCLAT was of the view that NCLT had taken into consideration the benefit of the financial creditors, so that even if he doesn't return or something like that happens, in such case, these bonds will take care of the security of the financial creditors. And of course, we'll have to remember that with this permission alone from NCLT or NCLAT, the bankrupt won't be able to travel abroad. These are without recourse or without any effect to the other proceedings going in ED court or the High Court and other places. So the bankrupt has to obtain permissions from there. But this is also another barrier because insolvency bankruptcy code is also there. So he has to, this is the permission from insolvency bankruptcy code perspective. So with this, we move to the next slide. Viewers, now we are in the screen of section 66, dashboard of section 66. Our next attention is topic number 8, which says that those taking part in fraudulent transactions should be punished. The case we are going to peruse is Mr. Lalit Modi versus Ashish Singh and others company appeal, which is a very recent judgment. Let us go to the excerpts of the judgment. I would strongly recommend that you go through the judgment. This is a long judgment and a beautiful judgment in section 66. There are a lot of things to learn from here, and I don't know whether this is the famous Lalit Modi or not, but the name is similar. So please go through this. So in order to elucidate or in order to bring the thing in a tabulated manner, I prepared a slide for you, and let me take you to the slide. Now, in this particular case, what happened was there was a claim lodged by Mr. Modi of 48 crores, 48 lakh 50,000. And the RP and IRP, they rejected the claim on various grounds that loan documents were not proper and they were not adequately stamped and all that. Now, there was definitely a question as to how could RP or IRP, this is a summary matter, do they have any jurisdiction, and does adjudicating authority have jurisdiction to satisfy itself of the genuineness of the loan agreement? So the court held, NCLAT held, that Regulation 10, 12, and 13 of CIRP Regulations 2016 enjoins upon IRP or RP to verify claims submitted by creditors, including calling for evidence and clarifications for substantiation of the claims. Hence, there was nothing abnormal or unusual on the part of adjudicating authority to have undertaken to satisfy itself of the genuineness of the loan agreement. It's automatic. If IRP or IRP is doing this, then who is the decision-making authority? It's the adjudicating authority. So in the balance sheet, it was seen that this 48 lakhs 50,000 was against the name of Lalit Modi under the head other advances, but not under the category and other long-term liabilities. Not under. So adjudicating authority did not commit any infirmity in holding that the advance, but purportedly given by the appellant, not having been classified as a borrowing in the balance sheet. Hence, it cannot adopt the color of financial debt. There was another fact. This loan was given about 10 or 15 years back. And there was no demand made by the creditor. So The court held that it is rather unusual that appellant remain indifferent in demanding repayment of the loan and for nearly 15 years, and and only on when the CIP proceeding started came up with the demand. So the court was of the view that this unusually prolonged delay in raising demand until CIP created doubts. There was another funny incident in this particular case. The bank statement showed that this loan was given on 19/4/2007. And on the same day, a disbursement of equivalent amount was made for purchasing an Audi A6 car. Now, the terms of the loan was exclusively for property land development. Now, when the purpose of the loan was for land development and the utilization of the fund, that is the day it comes into the bank, the same day it gets utilized for payment for an Audi A6 car, was definitely not proper. So the court held that this particular matter, this particular item of 48,50,000 was a fraudulent transaction, buying the Audi car with this, buying Audi car with this. So, and asked the directors to return the money or the third party to return the money. So this was perfectly coming under both 66(1) and 66(2). So this is an interesting case. And we have one more, I think, in Section 66 matter. So let us shift from here and go there. We are still on the dashboard of Section 66. Our focus is topic 35, which says that the initial burden regarding establishing transaction as fraudulent is on the RP. But the RP could not be compelled to tender that evidence which was impossible for him to file. So we have done one case on this earlier. We have discussed one case on this earlier. Now, this is another case which has come up during this week. This is Worldwide Online Services Private Limited versus Mr. Nand Kishore Vishnupad Deshpande. So let me take you to the case. This is quite something of a judgment. I would strongly recommend viewers to go through the excerpts of the judgment as you see on the screen, because you will know how this basically in gold and trading houses, how fraud can be committed. But however, for the purpose of this particular podcast, what I have done is I've prepared a slide for you, and let me take you to the slide. Now, what we see in this particular case is that the CD was keeping 3 ledger accounts of the appellant in the name of Worldwide Online Services Private Limited Purchase Ledger, Worldwide Online Services Private Limited Jewelry, and Worldwide Online Services Private Limited Sales. The entire ledger pertaining to the period to 1/4/2015 to 25/2019 were assessed and showed that rupees 98 crores 96 lakhs 82,438 outstanding for more than 2 years had vanished, was payable to someone but had vanished. Here, the RP had moved 19 to petition because the CD did not give any details. Even the Director of Revenue Intelligence had raided the site. They had seized the documents, and RP managed to get some information through Director of Revenue Intelligence, including financial statements, which were seized by DRI at the time of raid. Now, glaring discrepancies were observed by adjudicating authority. When the case came up, the statements which were obtained from the DRI and the CD then compelled by the circumstances, gave certain financial statements. And the best part, the statutory auditor declined to give any documents because he said that he has not. So there was big amount of discrepancy, and it was seen that 98.97 crores had simply vanished in air. And that was only by passing some fraudulent entries and was wiped out by doing fraudulent paperwork or fraudulent entries, whichever you can say. The CD was raided by DRI in the month of May 19, and thereafter RP has not found any inventory of gold. As I said, I must have told you that there was mentioning uh, books of accounts for jewelry. So there had to be, and it showed inventory in terms of gold. But when when DRI raided the premises of the CD, they did not find any inventory of gold. And then later, RP also did not find any inventory of. So the NCLT and NCLAT were of the opinion that there is no need to go into the question of presence of mens rea with the applicant or suspended directors of the city, as it is very difficult for RP to have proved the same by tendering any direct cogent evidence. This entire thing was done by mere fraudulent paperwork. 98.97 crores vanishing in thin air. So how could RP knew from the books of accounts? It was very obvious. It was observed. But how it happened, exact evidence of it, it was impossible for the RP to find it out. So RP had also reported to the COC of the CD that no inventory corresponding to the transaction shown by appellant was found by RP at the premises of the CD. Thus, NCLAT held that it is crystal clear case where false entries have been made in the financial statement of CD in collaboration with the appellant. And this was very much attracting Section 66 subsection. It was the directors who had done it. So they were asked to pay to the CD 98.97 crores. So this is one of the landmark judgments of NCLAT in matters of Section 66. And for many of us who used to earlier think that judgments never come up, Section 66 petitions are filed and usually no orders. The case keeps lingering on with no judgments coming. But you can see the trend has changed. Now we are getting multiple judgments on Section 66. So court is looking at it, and this is becoming a very strong NCLT and NCLAT are making very strong platform to punish the truant promoters. So with this, we move on to the next topic. We are on the screen of dashboard of Regulation 36A. The case we are going to deals with both Regulation 36A and Section 31. 36A, this deals with very important topics. We all more or less know about the topic, but there was no definite judgment pertaining to this. And frankly speaking, I really enjoyed going through this particular case. So, topic 23 of Regulation 36A states that Regulation 36A does not contemplate publication of fresh Form G when timeline is extended. This is, in fact, in one of my cases, I get calls and emails from PRAs that why I'm not publishing another Form G and because the timeline is extended. So this particular case, NCLAT has mentioned very clearly, Regulation 36A does not contemplate publication of fresh Form G when timeline is extended. The extension amounts to extension of all timelines, like last date of receipt of EOI, publication of provisional list of eligible PRAs, the time for filing objections to the parties' names, inclusion in the names of list in the PRAs, and issuance of FPRA. That is final list of prospective resolution applicants. So this is a very important judgment. Now, the case is the Committee of Creditors of Nirmal Lifestyle Kalyan Private Limited versus Shailendra Ajmera. This matter involves home buyer, and this is a lovely case, frankly speaking. I really enjoyed going through this particular case. And this is a case where the loser of the case has actually won it. So I would strongly recommend the viewers to please go through the excerpts of the judgment which is featuring on the website, both in section 36A and 31. So in order to elucidate to you in a concise manner this particular judgment, let me take you to the slide share. I've told you the topic in 36. Regarding section 31, the topic is topic number 55, which says the liquidation order may be set aside to let COC consider a resolution plan, keeping in view the objective of IBC is to revive a corporate debtor, and liquidation is the last resort. So in this particular case, what happened was the NCLT had issued a liquidation order. Now, the basic problem arose with who is the PRA, FPRA. And the plan was approved, but the plan was rejected by the NCLT. On what ground? That on multiple grounds, but the main ground was that the resolution applicant was not eligible under section 36A and 39 IBC. Now, what was seen that on 4th COC meeting held on 29/5/2003, 23, the COC had extended timeline of 30 days and extended the last date of receiving the submission of resolution plan up to 3/7/23. Then subsequently, on 7th meeting, again, they accepted the EOI submitted by Lakshmi Civil Engineering Services Private Limited and also Static Envir, two parties. Subsequent to the 7th meeting, and in the 7th meeting, they further requested the NCA for an extension of 60 days. Then subsequently, on the subsequently in another COC meeting, the COC decided that whosoever has submitted EOI, let the EOIs get evaluated and they be accepted in the final list of resolution applicants. And thus that way, the consortium Mr. Dharmesh Jain was also included in the PRA list, the PRA list. And the resolution plan submitted by consortium of Mr. Dharmesh Jain was approved with 89.2%, if I'm not wrong, yes, vote share. Now this matter went to NCLT. Now what it appeared is that the RP had duly intimated the NCLT that the the list of FPRAs, amendment of list of FPRAs during various stages. But with regard to Mr. Dharmesh Jain, consortium. This was not being done. But however, so when Form G contemplated extension of timeline, so court held that when Form G contemplated extension of timeline, the timeline got simultaneously extended for publication of final list of resolution applicant, provisional list of publishing provisional list of PRAs, the objection list. So there was no irregularity as far as that is concerned. The irregularity took place because Dharmesh Jain's consortium of Dharmesh Jain, that was not circulated. That was not published. What says that FPRA list should be sent to the committee of creditors and also all the other applicants, which was not done. So the court was of the view that NCLT was correct in rejecting the plan of Dharmesh, consortium of Dharmesh Jain. But fact remained that there were home buyers who were in favor of the plan being submitted by Dharmesh Jain being accepted. They were of the view. So court, considering the fact that there were home buyers, the intention of and the whole objective of IBC is resolution. So the liquidation order was set aside and court granted time to RP to continue the CIRP process, publish Form G again, and have the whole thing regularized, and then submit the plan to COC for approval and adjudicating authority for approval. So though Dharmesh Jain, consortium of Dharmesh Jain failed here, but actually if you think of it, he has actually won, because it is obvious that, I shouldn't say obvious, the chances are much more that he's the one who's going to win. So this is an interesting case. With this, we take you to the next slide. Now, viewers, we are on a case which deals with Section 60 and also Section 31. This is a Supreme Court judgment. So in Section 60, the topic is the adjudicating authority cannot exercise its jurisdiction over matters divorce the insolvency proceedings, and such matters fall outside of the realm of IBC. The case is Gloucester Limited versus Gloucester Cables Limited. This is a Supreme Court judgment. Let me read out the topic once more. The adjudicating authority cannot exercise its jurisdiction over matters divorce and insolvency proceedings, since such matters fall outside the realm of IBC. This particular matter also deals with Section 31 and Topic 87 also. What does Topic 87 say? The mandate of legislation is either to approve the resolution plan or to reject. There is no provision for making alterations or modifications in the resolution plan. So NCLT has got power only to approve or reject. They don't have any authority whatsoever to make alterations or to make modifications to the resolution plan. So this is an important case. It deals essentially with the patent Gloucester, who could issue the patent Gloucester. This was a case between Fort Gloucester and Gloucester Cables, the SRA of Gloucester Cables. This is the Supreme Court judgment. Obviously, on Supreme Court judgment, it's altogether a different. It's on altogether a different platform, and the kind of wisdom displayed is really, I would hats off to that. So instead of going through these two judgments and explaining to you, I prepared a slide. So let me take you over to the slide. I've already read out the topics So I'm not going into repetition of the same. Here, as I said, the basic fight or dispute was pertaining to the trademark Gloucester, which the Fort Gloucester said the trademark remains with them. And the Gloucester Cables, SRA of Gloucester Cables stated that the trademark remains with Gloucester Cables, the SRA. The adjudicating authority, which was NCLT Kolkata, while giving the judgment, they mentioned that the trademark remains with the city. And they also said that there had been an undervalued transaction in terms of Section 45 of IBC, 45 2B of IBC. And considering that they had made, I mean, in the pertaining to this particular proposition, they had made this remark, and this affected obviously the resolution plan. So the matter went up to Supreme Court. The Supreme Court was of the view that what is clear is that at the very least, even approved plan, it was the understanding of the appellant that there were rival claims over the title of trademark Gloucester. The RP did not move any application for avoidance transaction or undervalued transaction, allegedly defrauding the creditors. The SRA was fully aware on the date of submission of resolution plan about the agreement between FGI and that Fort Gloucester India Limited and Gloucester Cables Limited regarding the trademark Gloucester. So under the circumstances, adjudicating authority could not have, while approving the resolution plan in the present form, on which the Committee of Creditors had already voted, gone ahead and granted a declaration in favor of the appellant about the entitlement of trademark Gloucester. Trademark, this was not the subject of resolution plan, neither the subject of IBC proceeding. This matter had to be resolved by a civil court. So this was absolutely unnecessary on the part of the NCLT to have made a remark. But who owns the trademark Gloucester? The issue of title of the trademark was not in relation to insolvency proceedings or the fact of the present case. The residuary cause clause of Section 16, subsection 5 cannot be taken advantage of to short-circuit judicial or quasi-judicial proceedings, which NCLT had unfortunately done. The adjudicating authority cannot exercise its jurisdiction over matters, dehouse the insolvency proceedings, since such matters fall outside the realm of IBC. And it should be remembered that the plan as it exists only duly approved by COC, while adjudicating authority on application of GCL, no direction could have been made by NCLT conferring better rights. So this was wrong. NCLT had opined in that favor. And most importantly, the findings of NCLT that the matter was hit by Section 43 and being undervalued, it would be hit by Section 45, subsection 2B, are perverse in cross violation of the principles of natural justice and beyond the scope of inquiry. Because this question was not raised by neither by the RP, nor by the SRA, nor by anybody. And who was an NCLT adjudicating authority to state that there was an undervalued transaction? So the matter was reverted back. Supreme Court set aside the judgment. And it went back. The NCLT's view was upheld with some observations. NCLT had also made a small remark which was expunged. And this is a very interesting case, and I think you should go through it. So with this, we move to the Next topic. Viewers, we are in the dashboard of corporate insolvency. Our next focus is section 21, which deals with committee of creditors. The topic, incidentally, is also topic number 21, which says that exclusion of any member of the COC, however small the voting share it is having, is a serious issue. And the same could only be decided after providing ample opportunity of being heard to the parties. It's a very recent case of Jogihali Wind Energy Private Limited versus Yogesh Mehra and others. This is a recent though this is of section 2022, don't think that this is an old case. It came out, the judgment came out last week itself. The details are here. It so happened that Mr. Yogesh Mehra was inducted in COC and then he was removed by and NCLT removed him from the COC, and the matter went up to NCLT and it was adjudicated upon. So, and this deals with ILFS also. It's an interesting judgment. We don't get often section 21 cases. So I would strongly, like all other cases, I would strongly recommend that you please go through the website and see the case. I've just given you a brief. So let me take you over to the slide. I've already mentioned about the topic, so I'm not repeating on the same. Now, the NCLT observed that the learned adjudicating authority, while dealing with the controversy regarding the nature of the debt, noted that the voting percentage of the appellant in COC was not sufficient to change the fate of the resolution plan. It was very insignificant, but yet he did consider to remove Mr. Yogesh Mehra, though it was found that his voting share was not sufficient to change the fate of the resolution plan. Now, this complaint was supposedly lodged by IDBI Bank, and later it was found that IDBI Bank name had come up by mistake only. The adjudicating authority held that admittedly ILFS group of companies in the instant case are a group of companies of ILFS Finance against whom money laundering cases have been initiated by ED, and thus held that appellant IK and FS group of companies must not be allowed to be a part of the COC. So, but at the same time, as I told you earlier, the name of IDBI Bank appeared to have been inadvertently cropped up along with the respondent one of Yogesh Mehra. So, how it had happened, we don't know, but so this was noted by NCLT. But what NCLT noted was that the adjudicating authority, while recording this observation, had not discussed any material or evidence which may suggest that appellant and other two related companies known as ILFS group of companies are in the group of companies of ILFS Finance. ILFS group of companies and other 5 companies which are direct and indirect subsidiaries of IL&FS Energy Development Company Limited, LEDCL, had executed MOU with CD. Now, incidentally, what was observed is that no money laundering case, was filed against the ILFS group of companies involving CD. involving CD had been registered. There was no ECIR lodged by ED or any other relevant materials before the adjudicating authority. On what basis the impugned observation had been made in para 28 of the impugned order. So when there was no ECIR filed by ED, when there was no complaint of money laundering against the companies involving the CD, adjudicating authority on its own, based on some news clippings or whatever assertions of maybe counsels, would not have possibly made a remark that no parties, I mean, no party having connection with ILFS group can be member of COC. So consequently, the direction have been passed, the company must not be allowed to be a part of COC. These observations are in our consideration, may not be allowed to remain in the judgment. So court held that exclusion of any member of COC. You see, IBC is a mechanism. CIRP, call it CIRP, call it liquidation. It is a creditor-driven process. And opinion of every creditor is very, very important. How insignificant of his voting power. So exclusion of member of COC of a member of COC, howsoever small the voting share it could be having, it's a serious issue. And the matter same should be decided, provided, and after providing ample opportunity of being heard to both the parties. Otherwise, it will be breach of natural justice. So this is a very important case. And this is one of the judgments, particularly involving ED and others. So I would strongly recommend the viewers to go through the judgment. And remember, if you want a copy of the slides here, which I have, the slides which I have prepared, you're most welcome to ask me, and I'll be happy to share it with you. So with this, we move to the next topic. Viewers, you can see on your screen the dashboard of Section 12A, corporate insolvency. I presume this particular topic is coming up for the first time, and that is what makes it so novel. The topic number is 50. It says that insofar as group settlement, it is always open for the appellant to request the FC to file an application under Section 12A if any settlement takes place between the parties. We have heard of group insolvency, group CIRP, but we have never come across group settlement. And that's what makes this case exceptional. The rest of us is just a procedural matter. So this is extremely important. The cases of Ramesh Patankar versus IDBI Trusteeship Limited. It's a very recent judgment of 2026, as a matter of fact. Insofar as group settlement, it is always open for the appellant to request the FC to file applications under Section 12A if any settlement takes place between the parties. It's a simple case, small judgment, I suppose 4 pages. So but still then this is a landmark thing happening for the first time, possibly. So I would recommend all my viewers to please go through the judgment. While, without wasting any time, I take you over to the slide. Now, in this particular case, what happened was CIRP was permitted to be withdrawn by adjudicating authority, that is NCLT. On settlement, an application for revival of IA so-and-so was filed by FC, which was rejected in 2021-12-2022. So matter went to NCLT, and by order dated 15/5/2023, CP was revived. Before adjudicating authority to proceed according to law. The financial creditor thereafter did not approach NCLT for nearly about 2 years. So when they went to adjudicating authority after 2 years, adjudicating authority imposed a fine of 50,000 rupees, but admitted the company to CIRP and appointed an RP. So the NCLT was of the opinion that the fact remains that FC approached this court for a delay of more than 2 years, for which a cost has been imposed by adjudicating authority on FC. No error has been committed by adjudicating authority in passing the impugned order, appointing the IRP, since the IRP was to be appointed in the application as paid by FC. But NCLT did find in this particular case that there was no necessity for adjudicating authority, that is the NCLT, to pass an order for revival of corporate insolvency process, because that was already done by NCLT. Now, the appellant, that is Ramesh Patankar, that is the suspended board, one of the suspended board of directors, said that there was a talk of group settlement because other companies were also in CIRP, was being taken place. So NCLT made the remark that insofar as submission that steps were taken for group settlement, it is always open for appellant to request FC to file application under 12A if any settlement take place between the parties, and then you know the procedure, how the settlement takes place. So a group settlement can also be ordered by NCLT. So possibly one application can be made for a number of companies which are going through group insolvency process. So this judgment makes it, this is for the first time I'm seeing at least. I don't know about whether there has been, but for me, this is the first judgment I have seen pertaining to settlement of group insolvency. So that's why this particular, I had to include this in this presentation. It's a very recent judgment you can see of 2026, and we should all remember it. So with this, I take you over to the next.
Viewers, you have seen quite a few judgments. I hope you like them. Some judgments are going to follow hereafter, and they are also interesting, equally interesting. I'll be very happy if you will kindly give comments to this podcast when it appears on uh, YouTube so that I know your reactions. Share it with others, subscribe to the website, subscribe to the channel, and give your likes and dislikes. As we like the positive comments, we like negative comments also because that helps us in improving. So, with that, I take you over to the remaining part of the presentation.
Viewers, now we are on the screen of section 7. I suppose we'll be doing 2 or 3 cases on section 7. Section 7 is very common, but these topics are uncommon. These are coming up for possibly for the first time. So we are presently going to look at topic number 148 of section 7, which says that it is not open for the MSME to agitate their request for restructuring belatedly without having cooperated in the conduct of restructuring exercise when it was undertaken by the financial creditor in the first place. Let me read it out again. It is not open for MSME to agitate their request for restructuring belatedly without having cooperated in the conduct of restructuring exercise when it was undertaken by the financial creditor in the first place. The case is pertaining to Jagdish R. Pahuja versus Punjab National Bank. This is also a very recent case, possibly last Friday. Last Friday or Thursday. The details are here. I would strongly recommend, if I go through this particular video would last for 2 hours, so there is no meaning for it. Let me make it, summarize it for you and present to you in the form of a slide. So let me stop the screen share here and take you to the slide. Before going into this particular case, I would like you to remember, I have covered this in one of my podcasts. I don't remember which one. The Supreme Court judgment in the case of Pronits versus Board of Directors of Canara Bank. This was in matter of 2024, possibly came out in 2025 itself, wherein the Supreme Court held that banks must follow the framework for revival and rehabilitation of MSMEs contained in the instructions and directions prior to classification of the borrower's MSME account as a non-performing asset. So this necessitates, Supreme Court has very clearly mentioned that the framework of revival of rehabilitation of MSMEs, which is a framework introduced by RBI, and that to follow the directions prior to classification of an MSME as a non-performing asset. Now we come to this case. The total amount of debt claimed was 39 crores, 39.19 crores, which is included in the amount in default, and the default term loan agreement, as per term loan agreement, inclusive of interest and penal interest, the date of default was 30/6/2023. In the NESL record, the default was under authenticated status of category. So there was no ambiguity as per the existence of the default, debt and default. The appellant had approached the letter on 2/9/2024 seeking for restructuring of the loan facility. So that also amounted to acknowledgement of debt. So there was no question of limitation also. Now the only defense for the MSME was that the bank had not followed the dictum of Pronit's judgment. Now, court NCLAT went through the correspondences between the bank and the MSME concerned and observed that Pronit's judgment emphasizes on a reciprocal obligation on the MSMEs to be vigilant and follow the process laid down under the framework by producing authenticated and verifiable documents prove its eligibility to avail the benefits of the said framework. Now, in this particular case, the bank was constantly suggesting the MSME to do stock audit. And for more than a year, they were not doing it. So while the bank was approaching them, they were not doing. So there was nothing wrong in the bank to have approached NCLT for restructuring. So it is not open for. So the NCLT observed that it is not open for the MSMEs to agitate their request for restructuring belatedly without having cooperated in the conduct of restructuring exercise when it was undertaken by the financial creditor in the very first place. So if you are not vigilant and if you do not act in time, if you are sleeping, then you are caught in the wrong foot. And the Section 7 will get admitted. So this is a nice case. I suppose you can, in the Guide to website, Guide to IBC, you can see the Pronit's judgment also. So both taken together should give you an insight of the entire thing. This is important because MSME is involved. This Section 7 is involved. And overall, this is a new thing. This is not exactly a new thing, but a new thing. Definitely not coming every day. So I would recommend all my viewers to please go through this. So with this, we move on to the next topic. Viewers, we are back in section 7 dashboard. We have done topic 148. Let us go to see topic 147. What does the topic say? The CD with the leave from AA, that is adjudicating authority, can deposit entire default amount with NCLT, which can be paid to FC on determination of the debt by DRT. The case is Raj Singh Gehlot versus Anup Kumar, IRP, NCLT judgment. I repeat the topic, the CD with the leave from AA, that is adjudicating authority, can deposit the entire default amount with NCLT, which can be paid to FC on determination of debt by DRT. So here what you're saying, IBC is stating that yes, FC will be paid after the debt is determined by DRT. This is a lovely case. I doubt, I mean, this is really fantastic judgment. I mean, a very, very short summary or short press, even the pressing of the pressing, which I've told you, sounds interesting. So I would strongly recommend that you go through this judgment. This is a long judgment, and they're being very interesting. You should go through it. Let me take you to the slide. So I'm not repeating on the topic. So this is a section 7 filed by a bank against the CD, claiming that there is a default payment of 119 crores 94,658 and 68 paisa. 650 and 68 paisa. Adjudicating authority issued notice for fixing the matter on 2/2/26. The notices and the next date was already fixed. The corporate debtor, on hearing the complete matter, the adjudicating authority did not enter with the amount of default which they were stating, and was ready to pay the entire amount, but they insisted that find out the exact amount of default. Now the bank had also filed a surfacing proceeding at DRT. And NCLT, as we know, it's a summary judgment. They are never going to find out on the exactness of the default, on the amount of default, exactness of the amount of default. So the court asked the party that why don't you pay 119 crores to the bank? They said, no, we will not pay. Instead, we will pay it to NCLT. And let NCLT keep the money. Let DRT determine because it comes under the jurisdiction of DRT in the filed by DRT pertaining to the surfacing proceeding which has been filed by DRT by the bank in OA 258 of 2021. It's pending consideration. So let them determine the exact amount of default. And if the existing amount, I mean, if the exact default amount is determined, the 119 crores which they have claimed is lying with NCLT. Let the amount go to them. They have no objection. But if the amount is less, then bank gets less. So we find it out at DRT. So adjudicating authority who had passed an order of admitting it to section 7 was considered to have, it was NCLT considered that adjudicating authority had committed an error because the default amount the party had already submitted. And the determine the exact amount of default. So there was, nobody could say that the company was not willing to pay the default amount, but subject to it being found. The company has, constitutionally has a right. So they cannot be arm twisted to pay the entire amount. So determine the exact amount of default and take the money. And the company and declined to pay it to the bank. They said that let the money remain with NCLT, 119 crores. So adjudicating authority, under the circumstance, though it had admitted the company to CIP, NCLT declined. NCLT expunged the judgment, set aside the judgment, and set the company free. This is no doubt a very interesting case. So I would, and this is possibly for the first time, NCLT has withdrawn or set aside a CIP judgment and said that let the amount be determined by DRT, and based on it, the matter will get settled. But for the time being, there is no CIP proceeding because the party has already deposited the default amount with NCLT. So this is what makes this case exceptional. And I would strongly recommend that my viewers should go through this judgment. We are still on the dashboard of Section 7. And we are coming to topic number 7. We are coming to topic number 7, which says that it is the nature of transaction which determines the maintainability of the application. I repeat, it is the nature of the transaction which determines the maintainability of the application. The case is Mridul Balawant Kulkarni versus Kakumanu Lakshmi and others, etc. Though this is case of since 2023, the judgment came out last week only. And this is another very interesting case. Very interesting case. And this pertains to home buyers, but on a completely different scenario. The case of home buyers, but on a completely different scenario. And that is, this is not exactly the usual one which we see, that a home buyer filing for petition and then the case follows. Herein, the case was withdrawn with the consent terms and then refiled by home buyers. So, with this, with a request to my viewers to go through the excerpts of the judgment on the website, I take you over to the slide which I prepared for you. Now, in this case, what happened was, initially, a group of 6 flat owners had approached NCLT against the developer, which is the corporate debtor, and obtained an order under Section 7 of IBC. Subsequently, it was settled under Section 12A in terms of a repayment plan, in terms of a settlement term, in which the corporate debtor agreed to take these flats which were in default and pay license fees for it, and issued post-dated checks worth 1 crore 94 lakh. The checks were presented, came back dishonored. So based on those checks, the home buyers went in and filed a CIP proceeding, which was admitted by the adjudicating authority, and an IRP was appointed. Now, financial creditor was initially on the view that these guys are speculative investors. Now, NCLT held that the amount which was acknowledged to be paid in the consent terms was amount arising out of the allotment letter issued in favor of respondent 1 and 6. So agreeing to pay outstanding amount of financial creditors by post-dated checks were issued. Post-dated checks were given, and when they were dishonored, the company petition was filed. It is the nature of the transaction which determines the maintainability of the application. So under no circumstances, these people could be said to be speculative investors. At one point, you agreed with them that they are not speculative investors. The CIRP proceeding was withdrawn by a settlement. You had only agreed to take these flats on rent as licensee and pay the license fees, and you had paid 101 crore 94 lakhs by checks, post-dated checks, which got dishonored. So the speculative investor does not arise. But the corporate debtor herein came up with the view that whether the threshold, that is the exact number of home buyers, there is a limit in Section 7, that it has to be 100 home buyers or home buyers with or having at least 10% stake or something like that, is there or not. So this was a question at the time when the information regarding allotment of flat and other allottees, at the time of the matter was being taken up by adjudicating authority, that is NCLT, was not present. And also proof provided to the corporate debtor was not conclusive. So hence, the bench concluded that the present petition meets the threshold. But NCLT, that is the law, that is the natural justice. A benefit of doubt has to be given. So NCLT gave liberty to the corporate debtor to file an additional affidavit, bringing on record all relevant materials which relates to responding number of units allotted in the project within 3 weeks, and gave an additional opportunity to the respondents to file reply in respect thereof, and within 3 weeks, and remitted the matter back to NCLT. So even though this case was not, I wouldn't say that NCLT had returned the matter to NCLT. The appeal was allowed, but still then, this case is exception of exceptions in Section 7 and deserves attention of my viewers. So with this, we move on to the next topic. Viewers, we are now in the dashboard of Section 5. And our topic, our interest is, in this particular case, is subsection 13 of Section 5, which describes what is insolvency resolution process cost. We go to topic number 10, which says that as per definition of Regulation 31 of the CIRP Regulations 2016, any cost directly related to the CIRP and approved by the Committee of Creditors is insolvency resolution process cost. The cases of Lotus Auto Engineering Limited versus Dinakar T. Venkata Subramaniam and others. This is also a case of 2023, which the judgment came out very recently. Now, this is indeed an interesting case, wherein a corporate debtor was running business as a group company, along with its was an automobile machinery or parts manufacturer, and it was doing business along with its down the line group companies, which included Lotus Engineering also. The question came as to what is the insolvency resolution process cost. So in this, not only Regulation 31 was considered, also Regulation 34 was considered. And Section 513 was also considered by NCLT and NCLT. The judgment is very illustrative. You can see what is Section 513, Section 531, 34. So the court made an in-depth analysis, and also Section 28, because the role of CIRP was the role of COC was considered. So what was the CIRP cost was analyzed. So I'm not going into the details of the judgment, which I request with a request to the viewers to go through the excerpts. You will find it in the Guide to IBC website. So I'm stopping the slide share here with the screen share here and taking you to the slide which I have prepared for you. As I said, the CIP against AL commenced on 2017, 24/7/2017, and it is an admitted fact that Lotus is a group company of AAL. AAL was carrying out business of manufacture of automotive parts, along with its group companies Lotus and CTL. Even after CIRP commencement, the AL was run as a going concern, and for that purpose, the business model which was being followed by AL in collaboration with its group companies continued. So AL was manufacturing with the help of sourcing materials from Lotus and CTL. The Lotus had filed claim for pre-CIP dues of 23 crores. But however, in the resolution plan, which was approved on 9/7/2020, no payment was proposed to related parties. The claim of the appellant of pre-CIP dues got extinguished. During the CIP process, since the AL continued to do business through Lotus and others, they had made a payment to the extent of 170 crores to Lotus. And as per definition of Regulation 31, CIRP Regulation 16, any cost which is directly related to CIRP and approved by Committee of Creditors is insolvency process cost, but subject to it being approved by Committee of Creditors. And that is why Section 28 is important. Now, what appeared was the related party transaction. Now, the AL, I mean, the Lotus later mentioned that they had also lodged a claim of 23 crores, was not only pre-CIP cost. This was the CIP amount of expenses payable to them towards the services rendered by them during the CIP cost, during the CIP period. The related party transaction continued between AL and other group companies as per the business model prior to initiation of CIP. And the RP never placed the said cost to be approved by CIP before COC. And since it was never approved by COC, it did not become a CIP cost. AL had paid 170 crores, as I told you, but this 23 crores was also payable to them because they had done the work. But RP was of the view that this was a related party transaction, so there was no need to place it before the COC, Committee of Creditors. And since COC did not allow, the COC did not approve it, it could not become a insolvency resolution process cost under Section 5, subsection 13, read with Regulation 31 and read with Regulation 34 of CIP regulations. So the cost which was claimed by appellant in IA 170 of 21, we paid a CIP cost, having never been placed and approved by COC. The relief came by applicant, by appellant, could not have been allowed by adjudicating authority. This was little, I would say, this was, I wouldn't call it a, this is definitely, as far as NCLT is concerned or NCLT is concerned, without law being strictly followed, This there is nothing wrong in this judgment, but this is definitely a mistake which was done by the RP in not putting it up before the COC. And so a legitimate CRP cost did not get approved. So if any of us are doing CIRP, we should make it a point to put up before the COC whatever is the CIRP cost. Otherwise, this kind of fate is going to happen. So with this, we almost come to the close of this particular presentation, and let me take you to the last part of the video.
Viewers, we have come to the close of the presentation. I hope you liked the cases. There were some fabulous cases in this, some remarkable judgments. I hope the next judgments coming up in February will be equally interesting. And I hope I'll be able to bring you some more in-depth knowledge about insolvency and bankruptcy code. So for now, bye for now. Hope to see you soon again in February. Bye for now.